5 seconds to go. Start. The courts in such proceedings cannot decide where the parents should reside, as it will affect the right to privacy of the parents. We may note here that a writ court, while dealing with the issue of habeas corpus, cannot direct a parent to leave India and to go abroad with the child. If such orders are passed against the wishes of a parent, it will offend his right to privacy. A parent has to be given an option to go abroad with the child. It ultimately depends on the parent concerned to decide and opt for giving a company to the minor child for the sake of the welfare of the child. It will all depend on the priorities of the concerned parent. In this case, on a conjoint reading of clauses 1 to 3 of paragraph 55 of the judgment, it is apparent that such an option has been given to the appellant number 1. We may record here that an email dated 18th October 2021 addressed by the appellant number 1 to the respondent number 1 is placed on record along with IA of 2021. In the said email, the appellant number 1 has informed the respondent number 1 that during her visa interview, if she is asked, she will clearly state that the intended purpose of visiting USA was also to contest cases filed by the respondent number 1 and to file cases against the respondent number 1. Therefore, an option has to be given to the appellant number 1 to return to USA along with the minor son, though she cannot be forced to stay with the respondent number 1. Therefore, the respondent number 1 will have to make proper arrangements for a suitable residence for the comfortable stay of the appellant number 1 in USA. The reason is that the appellant number 1 cannot work in USA on the basis of a B2 visa. The respondent number 1 will have to provide a reasonable amount per month to the appellant number 1 to maintain herself and the child in USA. Necessary steps will have to be taken by the respondent number 1 to secure admission for the child in a school in USA. To enable the appellant number 1 to contest the custody petition filed by the respondent number 1, a direction will have to be issued to the respondent number 1 not to enforce and act upon the said order of USA court in any manner for a period of 3 months from the date on which the appellant number 1 reaches USA with the son. During the said period of 3 months, visitation rights will have to be provided to the respondent number 1 to meet the minor child. If the appellant number 1 opts to go to USA and contest the custody proceedings, the parties will have to abide by the result of the said proceedings in so far as the issue of the custody of the minor child is concerned. The appellant number 1 will have to be given time of 15 days from today to communicate the respondent number 1 her willingness to travel to USA with the child. If she intends to visit USA along with her willingness, she must communicate possible dates of travel. The dates should be within maximum period of 3 months from today. On receiving the same, the respondent number 1 shall arrange for air tickets and make arrangements for the comfortable stay of the appellant number 1 and the minor in USA, the respondent number 1 shall, for the time being, transfer US dollar 5,000 to the appellant number 1 for facilitating expenditure in USA. The respondent number 1 in addition shall transfer US dollar 1,500 to the appellant number 1, which can be used by the appellant number 1 for the benefit of the minor child in USA. The respondent number 1 will have to also provide a proper health insurance to both of them. The respondent number 1 will also be under an obligation to take care of medical treatment of the minor son. In the event the appellant number 1 fails to communicate her willingness to travel to USA within 15 days from today, it will be open for the respondent number 1 to take the custody of the child. After the respondent number 1 arrives in India, the appellant number 1 shall hand over the custody of the minor son to the respondent number 1 to enable the respondent number 1 to take the minor son to USA. To the above extent, the order of the High Court requires modification. Stop.